Hi, everyone. Welcome. My name is Andrew. I'm the owner and founder of IBIS Prep, reporting live from Coral Gables, Florida, which is home to the University of Miami. Repping my company, IBIS Prep. And today I'll be talking about ethics or professional responsibility, which is a very important subject on the exam. I always like to begin with a little bit about my business and a motivational quote. And you can see I have a really great team. I think I've discussed mostly all the tutors so far, Jeremy, Robert, Imani, Samantha, myself, and we also have Will, who should be added to this any day now. In particular, I would love to highlight Alexis and Simran, who are my administrative staff, and we're actually promoting Jesse to an administrative role as well. So we're here, we have a really diverse team. We teach for every subject under the sun. And you can see we provide for all these different subjects. We're really proud of our K through 12 department, where we teach elementary, middle, high school. We do GMAT, GRE, SAT. We really do everything and are happy to help any student in need. So as for the motivational quote from one of the OG nurses, Florence Nightingale, I attribute my success to this. I never gave or took any excuse. And really, that's what it all comes down to. There is no excuse. We're going to go out there and we're going to do our best. And we know that they'll be testing ethics. Ethics will be tested. So let's do it very diligently. Now, they could test you on any piece of ethics. So it's not one of those subjects where there's a whole outline dump. It's one of those subjects where you just identify which rules have been violated and you address them. So with this, off the top, what am I thinking about? Duty of confidentiality, conflict of interest, contingency fees. It can't be domestic or criminal. It needs to have a reasonable calculation of how it will be paid out. They need written consent if there's a conflict of interest, imputation if you're imputed on your firm and how we can work around that, duties of decorum, duties of confidentiality, duties of competency, duties of loyalty, duty not to commingle funds, when you can have an interest in the action as long as you have consent and they receive the opportunity to get assistance from outside counsel. These are some of the big things. Usually it's going to be conflict of interest. It's going to be commingling. It's going to be duty of confidentiality. And then a lot about reasonable fees and contingency fees. So let's just jump into the outline and really just go word for word on what we need to know. I attribute my success to this. I never gave or took any excuse. So if we look at the outline for the Florida Professional Rules of Conduct, we can look at our rules. Duty of confidentiality. A lawyer may not reveal information relating to the representation of the client, even after death, unless the client consents to full disclosure. Disclosure is implied, authorized in order to carry on the representation, prevent the client of committing a future crime, or prevent death or substantially bodily harm. Detect and resolve conflicts of interest. The scope is no more than necessary. Confidentiality versus attorney-client privilege. Attorney-client privilege is evidentiary. It applies only to communications made during the professional relationship, while the duty of confidentiality covers all information related to the representation, however and whenever derived. Conflict of interest. A lawyer may not represent a client if the lawyer's exercise of independent professional judgment may be materially limited by the lawyer's responsibilities to another client, unless the lawyer reasonably believes that the representation won't be adversely affected and the client gives informed consent. Conflicts with former clients. A lawyer who represents a client in a matter must not represent another client in the same or substantially related matter in which the former client's interests are materially adverse, or use information relating to the representation to the disadvantage of the former client. Prospective clients, a lawyer cannot divulge information learned during the consultation. a lawyer shall not represent a client with interests materially adverse to those of a prospective client in the same or substantially related manner if the lawyer received information from the prospective client that could be used to the disadvantage of that person in the matter and imputed to lawyer's law firm as well knowingly, except with informed consent confirmed in writing, or the lawyer took reasonable steps to avoid disclosure of additional info, and the lawyer is timely screened and written notices given to the prospective client. So we're looking for these conflicts, right? Conflicts of interest. We need informed consent, and the lawyer reasonably believes that the representation won't be adversely affected. Imputed disqualifications. The disqualification of a lawyer due to a conflict of interest with present or former clients is imputed to the lawyer's law firm. The exceptions, the conflict is personal in nature, and the conflict does not pose a significant risk of materially limiting the scope by the other lawyers in the firm. When a lawyer has terminated association with the firm may represent a client whose interests are adverse to the departed lawyer's client that the lawyer took with him unless it is in the same or substantially related matter, and no lawyer remaining at the firm has confidential information about former client as material to the matter. Compensation paid from a third party. Client must give informed consent, no interference with the lawyer's independence, and information between the client and the attorney is protected and confidential. The insurance company can receive compensation from a third party. When a lawyer is paid by an insurance company to represent the insured must receive a statement of client rights informing the insurer that the lawyer will follow the instructions of the insurance company. The lawyer may share confidential information from the insured with the insurance company, and the insurance company has the right to decide whether to settle the case. Usually, these are the client's decisions, but with an insurance company, they're actually going to have those decisions, because if it wasn't for the insurance company, they would not be a party to the case. And here, a third party can pay for it, but the lawyer still has a duty to adhere to the wishes of the client. Attorney's fees. In Florida, trial courts may award attorney's fees when provided by statute or contract, by rule, when recovery exceeds a certain percentage of a settlement offer, or for sanction for a claim or defense not supported by facts or brought for the purpose of unreasonable delay. The amount of fees is as justice requires, which means that there's great discretion. For fees, they must have confident evidence in the record to support the findings, and a reasonable person would agree with the court's order. Courts look into factors: the duty to charge a reasonable fee. Fees must not be excessive or illegal. Clearly excessive when it exceeds a reasonable fee or cost for service provided to such a degree as to constitute clear overreaching or an unconscionable demand by the attorney. And factors considered time and labor, precludes other employment experience, reputation, etc., and presumed reasonable if method and agreement contract is established. So Florida courts may only award attorney's fee when provided by statute or contract, by rule, or for sanction or defense, as justice requires. The duty to discharge, we have a duty to charge a reasonable fee. It is up to the client and individual attorney to agree on fees. However, fee must not be excessive. There are several factors in determining the reasonableness of attorney's fees: time and labor required, whether they will preclude future employment, conflict of interest, retainers, fees customarily charged in the region, amount involved in the results obtained, and time limitations. The award of attorney's fees, the nature and the length of professional relationship, experience, reputation, and ability of the lawyer, and whether the fee is fixed or contingent. Under Florida law, trial courts may only award attorney's fees when provided by statute or contract. Contingent fees is a fee dependent on the successful resolution of the case. Such arrangements must be in writing and include the method it will be calculated in the percentages. Contingent fees are prohibited in domestic relations and criminal matters, and the client must receive the statement of client's rights prior to signing the fee arrangement. The fee is contingent on the successful resolution of a client's case and payable from the judgment proceeds, prohibited in domestic relations and criminal cases. The writing requirements must be signed by the client and attorney. It must state the method for which the fee is determined, the percent to go to the attorney in the event of a settlement, trial, litigation, other expenses to be deducted from recovery, and whether it should be deducted before or after the contingency fee is calculated, plus the after recovery. The attorney, plus after recovery, the attorney must provide the client with a written statement of the outcome. In personal injury cases and property damage cases, prior to signing the agreement, the client must be provided with a statement of client's rights, which, among other things, informs the client of his right to terminate within 3 days the agreement without penalty. Joint liability: each participating attorney assumes joint responsibility for the client's representation. Contingency fee guidelines: between 15 and 40%, but a fee in excess of the guidelines is presumed to be excessive, but the presumption can be rebutted. So between 15 and 40% is a presumption. Remember, it's got to be in writing and calculate an explanation of how to be calculated. It's unethical to pay referral fees. However, which is often, it can be exceptionally paid when the attorney worked together with the outside lawyer. The fee should be divided attorney with the work performed, or in the client's fee arrangement, each lawyer assumes joint liability and discloses how the division of fees will be made. So referral fees are not ethical unless the other attorney actually participates in handling the case, which there's a pretty loose standard in reality, but for the bar exam, you look out for an attorney who's receiving a referral fee and not doing anything. Commingle, a lawyer must hold in trust, separate from the lawyer's own property, funds and properties of clients or third persons that are in a lawyer's possession in connection with the representation. All funds, including advances for fees, costs, and expenses, must be kept in a separate bank. A lawyer must not commingle funds. A lawyer is subject to discipline for commingling. A lawyer must keep trust funds in a trust account, except advances for costs and expenses, which may be held in a business account. A fee arrangement that gives attorneys interest in client property. Generally, attorneys cannot acquire interest in subject matter of litigation other than lien for payment fees. However, it's allowed if fair and reasonable to the client, disclosed in writing. Client must be advised to seek independent counsel, and client must give informed consent. So that's when they have an interest in the property. Like I said, the client needs informed consent and the opportunity to seek independent counsel. In Florida, a party may specifically agree to charging a lien to attorney on his homestead property. And then finally, advertisement solicitations. A lawyer must not make false, deceptive, or inherently misleading communication. An advertisement is deceptive and misleading when it contains a material statement that is legally or factually inaccurate, omits information that is necessary to permit the information provided to be misleading, implies the existence of a materially non-existent fact. Solicitation. A lawyer may not solicit professional employment from prospective clients with whom the lawyer does not have a family or prior professional relationship. Florida law prohibits solicitation by contact in person, through mail, by telephone or telegraph, or by other means. However, a lawyer may solicit an accident victim if in writing in at least 30 days have passed since the accident. Communication with persons represented by counsel. A lawyer must not knowingly communicate about the subject of the representation with the represented person without that person's permission, that person's lawyer's permission. And communication with the unrepresented persons. When dealing with unrepresented persons, the lawyer may not state or imply that he is disinterested. If the person misunderstands the lawyer's role in the matter, the lawyer must take reasonable steps to correct the misunderstanding. So advertisements can't be fraud or misleading. Solicitation, you cannot solicit unless you have a family or prior professional relationship, or if it's an accident victim and you wait at least 30 days. So those are some great rules that you can go over. One thing too, I wanted to go over too is this PowerPoint for sure. This right here is the best way to introduce a Florida ethics essay with this exact word. The ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida Rules of Professional Responsibility, the ideals and goals of professionalism, the oath of administration to the Florida Bar, the creed of the Florida Bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. Beautiful sentence. Beautiful sentence. Taking a picture right now. Referral fees. Fee arrangements must always be reasonable. When contingencies are involved, they must be in writing. Further, any agreement to share money with another law firm must be in writing, signed by the client, stating the terms of the arrangement, and in most cases, making the parties jointly or severally liable, or defining the arrangement by the amount to be work done. Attorneys have an affirmative obligation to refrain from making frivolous arguments. Frivolous arguments are those in which there's no basis in either fact or law for the argument, and the argument is not made in good faith for the alteration, extension, reversal, or modification of existing law. Arguments made solely for the purpose of delay and are obviously frivolous. Lastly, an attorney should not undertake a course of action solely calculated to embarrass or harass another. Under the business transaction rule, a lawyer cannot engage in a business transaction with a client unless the lawyer makes full and fair disclosure of the terms of the deal, confirmed in writing, the deal is fair and reasonable to the client, and the client is informed of the desirability of seeking independent counsel with respect to the transaction. We're looking out for conflicts of interest, like we said. An attorney may not represent another party if a conflict of interest exists that might materially affect the representation of the new client. The only time the attorney can do so with a conflict of interest is if he reasonably believes it will not affect his judgment or representation, and if the client consents in writing to the conflict of interest. But furthermore, with conflicts because of former clients, the attorney must not represent a new client that is adverse to the former client unless he reasonably believes it will not materially affect the representation and gets informed consent from the former client as well. Contingency fees. Contingency fees are permitted in civil cases except for domestic matters like alimony and child support. Contingency fees are not permitted in criminal cases. This is a non-domestic, okay? An attorney must charge a fair fee for his or her services based upon the complexity of the case, the amount of time it will take, what other similar attorneys charge, and the attorney's experiences. An excessive fee is one that a reasonable attorney would look down upon. The client is also entitled to a final calculation in writing at the end of the representation. However, contingency arrangements are also subject to the general rules regarding the reasonableness of fees. A lawyer cannot charge a reasonable fee. Factors that contribute to whether a fee is reasonable or not include the lawyer's education experience, the amount of time spent on the case, and the complexity of the issues. A lawyer who attempts to retain 50% of the recovery in a case was not likely a reasonable fee. The contingency arrangement would most likely be valid. An attorney may indicate to the unrepresented party is disinterested. That is, an attorney must disclose to the unrepresented party that he's acting in the best interest of his client and not the interest of the other party. Further, an attorney may not represent the interests of two clients whose interests conflict unless the attorney believes he can fairly represent both clients and receives consent in writing. A lawyer must not make a false, deceptive, or inherently misleading communication. An advertisement is deceptive and misleading when it contains a material statement that is legally or factually inaccurate, omits information that is necessary to prevent the information provided to be misleading, implies the existence of a material non-existence fact. Example, 100% win rate, but you only ever had one case. Solicitation. A lawyer may not solicit professional employment from prospective clients with whom the lawyer does not have a family or prior professional relationship. Duty of confidentiality. A lawyer may not reveal information relating to the representation of the client even after death, unless the client consents to full disclosure. Disclosure is implied, authorized in order to carry on the representation. Think partner gives associate information on your case to draft a motion. Prevent the client of committing a future crime or prevent the death or substantial bodily harm, to detect and resolve conflicts of interest. The attorney-client privilege is an evidentiary rule that applies only to communications made during the professional relationship, whereas the duty of confidentiality survives even death. Well, the duty of confidentiality survives all information related to the representation, however, and whenever deprived, like a convo on an elevator phone. Curiosity will conquer fear even more than bravery will, by James Stevens. I'm sure we're all asking the same thing right now. Who is James Stevens? And does IBIS Prep actually support this man? Oh, it's James Stevens. He was born in the paper chase. Never seen it. I don't know. All right, cool. Well, ethics, enough of James Stevens. Ethics easy, right? We just want to be diligent. We want to write as much as possible. I recommend writing ethics first. And the first thing you should write is this. The ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida Rules of Professional Responsibility, the ideas and goals of professionalism, the oath of administration to the Florida Bar, the creed of the Florida Bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. I made an outline from another state with some ABA rules that I think are really some good ones that we missed, like duty of candor, duty of competency, duty of decorum, duty of loyalty. A lawyer has a duty to act in the best interest of their client, which means avoiding potential and actual conflicts of interest. Representing two co-defendants raises a significant possibility that their interests will become adverse to each other in the future. Under the ABA and Florida rules, an attorney may represent two clients with a potential conflict of interest if he reasonably believes that the representation of either client, the lawyer's own personal interests, or the interests of his family will not materially limit his duties to the other. He informs the client in understandable language of the conflict and obtains written consent. So in the ABA rules, an attorney must advise a client of any conflict of interest and obtain consent memorialized in writing. Florida requires written consent to all conflicts of interest. Additionally, Florida requires a lawyer to advise on all potential and actual conflicts and obtain additional consent if a conflict actualizes. Duty of confidentiality, a lawyer has an obligation to keep all of a client's non-public information private and not to use that information against them. There are limited exceptions for when legally required to do so by statute, ethical rule, or court order, when the client consents, when the misrepresentation is at issue, such as a fee in a malpractice dispute, when necessary to prevent death or serious bodily injury, or under the ABA to prevent your services from being used to commit a financial crime or fraud. When an attorney represents co-clients, attorney-client privilege and confidentiality is waived as between them, right? Like in a subsequent case. A lawyer also owes a client a number of financial duties. The ABA prohibits contingency fees in criminal and domestic cases. A contingency fee is a fee where payment depends on the outcome. Usually the lawyer is only paid upon the resolution of a favorable result. There must be a certain information on the contingency fee, which must be in writing. The ABA requires the attorney's percentage of recovery, whether it's taken out before or after expenses, and who pays for which expenses. Under the ABA rules, the lawyer's fee must be reasonable in light of the experiences of the lawyer, time and preparation required, nature of the case, and the result achieved. Generally, when a lawyer is just discharged by a client they represent on a contingency, they may recover through a quantum merit for the work already done. Lawyer has a duty of competency. A lawyer has an obligation to completely represent his clients. Under the ABA rules, a client must employ the time, preparation, skill, expertise, knowledge, and experience necessary to reasonably represent the client. If a client does not have those factors, he must learn the relevant material if possible without undue delay or associate with a competent attorney. I like that. Duty of decorum. A lawyer also has duties in the court. Among others, a lawyer has a duty to uphold decorum in the court and behave professionally and appropriately at all times. They should act in a way that builds the confidence in the legal profession. Arriving at an arraignment with such serious lack of preparation that the court was forced to appoint alternative counsel and discharge the lawyer arguably violates those duties. The lack of preparation is clearly disruptive to court proceedings and inconvenience the court and the parties, so it violates the duty to uphold decorum in the court. Such flagrant lack of preparation also undermines public confidence in the judicial system by appearing to undermine the integrity of counsel. That's particularly important in criminal prosecution, where there's a strong interest in ensuring adequate representation on both sides. So those are some outlines. We looked at some PowerPoints. Let's see if I can count on one of my students. Just look through one of their questionnaires. See what we got here. The ethical duties of Florida lawyers are outlined in the decision of the Florida Supreme Court. The Florida lawyers are professional responsibility, the ideas and goals of professionalism, the oath of administration of the Florida bar, the creed of the Florida bar, and many other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for non-compliance. A lawyer may not reveal information relating to the representation of the client, even after death, and that's all those elements we talked about. Conflict of interest. A lawyer may not represent a client. The lawyer's exercise of independent professional judgment may be materially limited by the lawyer's responsibilities to another client, unless the lawyer reasonably believes that the representation won't be adversely affected and the client gives informed consent. Imputation is disqualification of a lawyer due to a conflict of interest with present or former clients, which is imputed to the rest of the client's law firm, except if conflict of its personal nature and conflict does not pose a significant risk of materially limiting the representation by other lawyers in the firm. The lawyer may be screened and separated from the case. We talked about duty of decorum is not to act a fool in the court. Duty of candor. The lawyer is required to present the law, facts, and evidence to the tribunal in a truthful manner, right? These are duties to the tribunal, duty of decorum and duty of candor. Duty not to commingle. A lawyer must hold in trust, separate from the lawyer's own property, funds and property of clients or third party that are in a lawyer's possession in connection with the representation. You can be paid for a third party, informed consent, no interference with the lawyer's independence, and information between the client and the attorney is protected and confidential. When may attorney's fees be awarded in Florida and what rules apply? In Florida, trial court may only award attorney's fees when provided by statute or contract, by rule, for sanction, the amount of fees as justice requires. And for fees, they must have competent evidence on record to support findings, and a reasonable person would agree to the court order. Referral fees, remember, were unethical unless the attorneys work together, and the agreement must be signed by the client, stay in the terms of the agreement, and in most cases make the parties jointly or severally liable. Contingency fees, only civil matters, prohibited in domestic and criminal matters, must be signed in writing, state the method fee calculated, percent to go to the attorney in the event of settlement, trial, litigation, whether it should be deducted before or after contingency fee is calculated, and after recovery, attorney must provide client with some outcome statement. What are the rules regarding attorney advertising and solicitation in Florida? So we talked about advertisement. Lawyer must not make false, deceptive, or inherently misleading communications. The ads must have the name of at least one lawyer or firm responsible for content, the city, town, or country of at least one office, disclosure of other firms' name if cases being referred, cannot use judges or officials, cannot contain material statements that are legally or factually inaccurate, omit information necessary to prevent from misleading. Solicitation, a lawyer may not solicit professional employment from prospective clients with whom the lawyer does not have a family or prior professional relationship. Florida law prohibits solicitation by contact in person, through mail, by phone, by telegraph, or by other means. A lawyer may solicit the active victim in writing if at least 30 days have passed since the accident, must state advertisement and contracting font, and please disclaim if you already have counsel. Good job, Joel. Really, really thorough. I love these questionnaires. All right, the last thing that I will show everyone is just a little bit of model essays and see where do we encounter these where do we encounter these issues? Oh, there's a lot here. The reason there's a lot is because ethics is tested every single year. So there's plenty of ethics, ones that we could see. We're just going to look at a few of them because they're pretty easy. Ethics is never tested alone, but it's always tested. Always tested. Never alone, but always tested. So here you see it tested at the end. What ethical issues does Luke likely face and what should he do? And you see that's probably the last thing they wrote about, but I might write about this first because, you know, when a lawyer is representing a client and after the lawyer passes the bar, they are presumed to have a certain competency level. However, Luke, as a business attorney, should be concerned with if he is competent to represent Charlie in a criminal matter, since that does not appear to be his area of practice. A lawyer can become competent in an area through study or working with another lawyer in the area of law. In regard to the criminal case, the fact that Charlie confessed to Luke is not problematic, as he is still entitled to a defense. The contract that Luke is working on for Charlie with a third party is where the ethical concern lies. Luke is not required and may not disclose privileged information provided them by his client. However, this is an ongoing criminal enterprise if Charlie continues to sell the copper. A lawyer may not participate knowingly when the use of his services is in the furtherance of an ongoing criminal enterprise here to sell stolen copper. Luke should not represent Charlie in the copper contract unless he can verify the copper is not stolen. See, quick and easy, but we want to get as many points on ethics as possible. What ethical issues would we have? I think this was my year, yeah, February 2017. I took this bar exam. Blast from the past. An attorney may not represent a client in a matter if his independent professional judgment would be materially limited by his responsibility to another client, unless attorney reasonably believes he could provide competent representation and the client consent in writing after consultation. When two or more clients are seeking to be represented by the same attorney, they must be made aware of the implications of doing so. Here, M and C have come to my office to seek representation in matters against H&W. As long as my independent professional judgment is not materially limited by my responsibility and representation of both them, I could do so without running afoul of the rules if I reasonably believe I could competently represent both and they consent in writing after consultation, which I share with both the implications of representing both. I was pretty solid about conflict of interest. Let's see, 2018, we'll do two more. Definitely want to know about fees, contingency fees, conflicts of interest. Duty of confidentiality. Maybe they started with ethics. No. Yeah. Attorneys can be held to mandatory reporting standard depending on the role. If, oh, this is actually going to be about dependency. I'm not going to get into that one. Sorry. Dependency is no longer tested. All right, let's look at this last one. Maybe I'll do two more like I promised. So real property ethics, right? It's a contingency fee. That's what I was looking for. Love me a good contingency fee. I love this. This is how I would start. Either start it like this or put this at the end. But I think the time is ticking. You want to get your points on ethics. I love this. First off, I would like to address the professional conduct issues involved in your suggestion to take this case based on the contingency basis by oral agreement. I would suggest that according to the model rules of professional responsibility and their adoption in Florida, any retainer agreement between our firm and our client should be in writing and signed by both the client and the attorneys who will be working on the case. This is the best way to inform our client about what we expect from him, cooperation and payment, and what we can expect from us. Estimate of hours to build, court time, withdrawal terms, etc. Although taking the case on a contingent basis is not an issue here, as it is with criminal or domestic matters, the percentage to be taken is far too high. Generally, the amount charged on a contingent basis is 33 1/3%, which can increase with the amount recovered. The written agreement should state when the fees and costs will be calculated, either before or after computing the percentage, and the client should be made aware. If we can make these alterations, we should be able to handle H's case without being subject to sanctions by the Florida Supreme Court and without opening ourselves up to malpractice liability. Good one about contingency fees. I'll just look at one more. From the year I graduated high school, July 2008, exactly then. Any ethical issues? Well, what do we have? During the consultation with our firm, L informed us that he was willing to forget, which means lie, that L ever told him that R was first conveyed to his brother. First and foremost, a lawyer in Florida is under no duty to disclose adverse effects to tribunal. However, this does not give a lawyer or his client free rein to misrepresent facts to tribunal or to opposing counsel. A lawyer has an ethical duty not only to act with candor toward the tribunal, but also prevent such misrepresentations from occurring. If we were to take L as a client and he filed pleadings with the courts, we cannot represent that his fact did not occur. When the lawyer signs pleadings, he is subject to ethical obligations that everything put forth therein is a true and good faith. This would be cause for sanctions against both of them in a 50-50 split. We would not be able to claim we relied on good faith in our client because he had told us it was not the truth. Further, and this is where they get lots of good points, if this went to hearing, we would have to affirmatively counsel that he must tell the truth and that he might not tell the falsity he wishes to assert. Furthermore, we need to explain the ethical obligations we are under. If he fails to take our advice, we would have to move the court to allow us to withdraw as counsel. If the court would not allow this, we would have to disclose such a misrepresentation to the court. Although we are not close to trial yet, this is something we should take into consideration when choosing to represent this client to spare the trouble later if he insists on lying. So you see, ethical issues are always tested. We want to tease out as many as possible. And I recommend writing it first. I probably wouldn't do the first off, I would like to the address. Instead, I would outline my essay. Part 1 is, contracts. Part 2 is L's claims. Part 2 is C's claims. Part D is ethics. Well, part D, I would write first. The ethical issues here are boom, right? I might even write damages second. The damages available are boom and boom, because I want to get my points on the test. Ethics is definitely going to be tested. I think I did a pretty thorough job of going over a lot of the ethical issues you can encounter on the test. Just be diligent. An attorney has a lot of duties, and we want to explain all those duties to the reader. So thank you so much for watching this presentation and for joining us on the Florida Bar Crash Course. Really wishing you the absolute best on your exam. My name is Andrew, and I'm always here for you. Have an amazing day.